Foundation, the managing partner, ALP East Africa, the Chief Operating Officer,
and intending practitioners. Of course, the training has been made possible with the support of Ford Foundation, represented by the Regional Director, who have supported this for some time. And the theme of the training is strengthening civic space, good governance, and the rule of law in East Africa through the East African Court of Justice legal architecture. As you will be told, or as you will be trained in these 2 days, the East African Court of Justice has been very, very instructive in amplifying the meaning of the twin concepts of rule of law and good governance in several judgments which you will consider through the 2 days training. The intention is then how can an advocate today benefit from that rich jurisprudence to serve an East African who wants remedies under those 2 twin concepts. That will be the focus of the training. You will learn that the platform exists at both the East African Court of Justice, but you will also learn that domestically you can ignite this procedure using the preliminary reference mechanisms under the ESCJ Treaty. What we would like to see at the end of the training and in the nearby future, that you as advocates are able and competently so, to deploy good governance and rule of law in your matters, both in Kenya and also at the court. You are not the first group to be trained or that will be trained. We are on the same level of understanding, such that when they file these matters before us, they do so in a manner that is easy for their clients, thereby serving the common mwananchi very competently. So the demand arose from that phase 1. This phase 2 has advocates, and we'll be training here 40 advocates initially, and then subsequently we will be training more advocates. As part of this phase, CEPIL has prepared 2 resource books. These resource books were launched at the East African Court of Justice premises on the 15th of May 2023 by the President of the East African Court of Justice together with the Principal Judge and all the judges. And it was developed after very thorough consultation with many practitioners who are in this space and the court itself. These 2 resources, one being the source book on good governance and rule of law in East Africa, is, I'll explain it very briefly, is a compilation of what the court over time has defined as what the meaning of rule of law in the East African community. So here you will find the jurisprudence summarized, and we'll also share a soft copy with hyperlinks, meaning that when you get this today, you can easily do a matter in your office without leaving your desk. So this has been prepared to aid practitioners who want to practice before that court. We will get copies, and we'll also share with you soft copies. The second book manual is a litigator's manual. The litigator's manual is the manual you will need if you have a matter before the East African Court of Justice. Again, it has all the key decisions on procedural aspects and on the substance before the court. We have as well attached at the end of it forms and the manner in which applications are expected in that court. So you will find that these two, as a leading practitioner in the area and before the court, honestly, I looked at my needs as a person who has litigated in that court for more than 10 years. What would I have wanted when I had my first instructions before that court? And with that mindset, we developed this. So you are going to have these materials, and these materials, I can assure you, are going to make your work very easy after you have gone through this 2-day training. So we expect that you will become experts after these 2 days. And what we request you to do, don't retain the knowledge. Train others, share the materials with others. If you don't have instructions on these issues, and there's a colleague who wants to file a matter before the East African Court of Justice or domestically in your courts, but based on the jurisprudence of the East African community, please share with them, because that is then how we will grow community law, because you, having been trained, will also be able to train others, and in that way we will be able to spread these community ideals that we so wish to practice. So I want to say thank you so much. You are selected after very many people, from a list of very many applicants. We looked at several things, but importantly, we saw passion in your applications. We saw passion, group of advocates who are passionate about EAC law. That was very primary in your selection to be part of this training. So I congratulate all of you for making it amongst very many applicants. And you all deserve a round of applause, because it was not easy for us to select only 40. We wished we would train more, but this is an elephant in itself. You start slowly, one part at a time. That's why we are saying when we train you, please also go and train others, okay? Is that something you promise us to do? Thank you. With those remarks, I thank all of you for coming, and I wish you a very nice 2 days of training and empowerment in this place. Thank you.
Thank you very much, Francis, for your remarks. So without wasting time, I'll invite Mr. Cohen Amanya, the representative of the Law Society of Kenya, to make his remarks.
Practice without being trained. I know how and what we faced. I'm happy that given time the next lot, I think I will also come in, because I can be trained. I'm still lacking some knowledge. And on behalf of the President, we are happy, and I know Mr. Gimara has asked me some requests that we consider giving CPD points. But I've told him on the procedure, and once that one is done, we shall see and consider it. And maybe for your information, for those people who have been trained, maybe you can attach the list and the hours they have taken, so that when we are considering them, we know the number and we know all that. But we thank you as Center for Public Interest Law, together with Ford Kenya, I know it's not easy to practice at that court because the dynamics of that court are totally different and welcoming. But at the end of the day, for me, which I want to leave with, maybe for Center for Public Interest Law, the question now that we have the East African Court of Justice, now that we have that regional court that helps us to mitigate on the issues that are in the country, but some of them cannot be litigated in the country because of the political nature of such cases. The question should be that even after the declarations are made, the enforcement of such, because I know as lawyers, we want to see after that sweat, after having sleepless nights, how will I enforce certain declarations? It is a very something that we are looking at, because some of the declarations are made. Once they are made, the partner states, some of them refuse to comply. Is there a mechanism that we can employ? And I know most of my colleagues will learn more from that. The last point is, as Ford Foundation, since now you are, 40 advocates to the Law Society is just a drop in the ocean. What I can tell you, we are 22,000 advocates. So you can imagine. So we implore you that when you consider in your kingdom, remember us that we are so many and increase the numbers. So then the training looks at 1,000 and more. And I know our members will want to join and be part of this process. I wish you well. I know I was talking to Mr. Francis Gimara. We are litigating a certain case which I will discuss with the registrar. I know I will not be told that it's sub judice, but the cases that are upcoming and how the drafting of the pleadings are done, it is very, very crucial. Because some of the cases, when they go for the preliminaries, some of them, of course, the court has adopted the system that they should not kick out cases because of such a default. But according to the rules of pleadings, if you don't plead specifically and you bring out your case, then you leave it to the court. Then the court will have no choice to dismiss the case. Because some of the cases that go to the East African Court of Justice, and if you read all of them, they are good. That's why we say that you look for people who have litigated at the ECJ for purposes of guiding you. Because cases, some of them, all of these cases you are seeing, cross-border, all these cases, they go to the East African Court of Justice. But because someone pleaded wrongly, it ends up being like a political case. And yet he has a case. That is something that I think out of this, you will be able to see on the issues of the pleadings. Then, preparations to the case, all those things. And I wish I had been told I would have applied to be part. But with those few remarks, on behalf of the Law Society, we are delighted and happy for such contribution to our members. Because we have 22,000 members. You can imagine, if we get a chunk of people who can now take over litigation at the ECJ, we as the Law Society will be happy because we are targeting a certain number of people. And Mr. President, I call him the President, Mr. Francis, when you consider next time, we have so many young lawyers, so many. These young lawyers, the senior lawyers, East Africa, traveling, all that, the money might not be too much, but to our young lawyers, we have so many, there are so many, and to the extent that they can do all those works at the ECJ in terms of mentions, in terms of. So as the Center for Public Interest, this is what I want to leave to you. Can you create like a hub where you can mentor these young lawyers to be able to be assimilated into the system? Because it will help us in terms of creating job opportunities and diverse on what is happening in this country. I thank you, I thank everyone, and I thank you for attending. Please, after training, you have been told that you go and train others. we as the Law Society will be happy that you conduct a training for the other members. We thank you very much. Thank you.
Honorable guests here that are on the plenary with me, and to all of you as fellow citizens and people in the search for sustaining justice. I wish you a good morning. We are very excited to see this happen and to see that it's also part of a series of investments really in strengthening the capacity of us to be able to do the work that we need to do in engaging these questions of good governance, of democracy and civic space. I know that civic space is what they call big English. And so what I wanted to do is to also explain, at the Ford Foundation East Africa office, civic space is the core focus of our strategy. And so I just wanted to explain, for us at least, what we mean by that. So the first component for us is the defense of basic freedoms and civil and political rights. So freedom of assembly, of association, of expression. The question of, we are now in digital worlds, and so we also have to think about how we do those in analog, which is how the original laws were written, but also to think about how do those map into the digital domain, because there are a lot of new questions that come up in the digital space. We think also then about the enabling regulatory environments for both people and the institutions or organizations that defend rights and advance justice and democracy. And we think about the systems to protect those people as they do it. And then we think about the narratives that shape our understandings of these questions, right? And to what extent in our popular thinking and the ways that we talk about what we do, whether there is a common embrace of the idea that indeed these are things that need to be defended, that these are things that are important. And I should say, too, that we have to remember that as much as these are questions of global legal conversation and international legal discourse, they're also rooted in concepts and ethical practices that exist in our societies that were also central to the creation of our independence constitutions. They are created by us. And so the question is, how do we then understand them for us? Okay, this is critical. These are questions. These are ideas that we have put as ways to frame our society, and we have put them into law as ways to protect them, right, and defend them, because we believe that they're important to the healthy functioning of our societies. And for me, this is critical, because we have to own this. We speak about the East African Court as one of the components of enabling a stronger East Africa. And as mentioned in the briefings for this event, there's a lot of focus on regional integration as an economic question, both within East Africa and in the broader African region. There's a lot of attention to that. There's also a lot of effort in it, right? We have the African Continental Free Trade Agreement, and there are other efforts to think about economic integration. We know that, again, the economic is not the only domain, and that we have to really think about this also in the legal domain, too. The other thing is that it's not just a question of having instruments or structures. We are the ones that make this real. If we engage the court, we make it relevant. If we respect what the court says, right, we give it power. Okay? And I'm sure, as they're saying, if we resource the court, it means that we're showing that we actually believe in its necessity. Okay? So we are the ones to make this real. And I think that as we do this again, there are many questions that we need to look at, and I'm sure in your training you're getting the big picture, you're understanding the process, but then to also really be creative in thinking about what are the most pressing needs that we're dealing with in East Africa, right? What are wananchi saying they need the most, okay? And to what extent are we in the legal universe and in the justice institutions responding to those needs? We know that there is a generalized call actually to really advance gender equality. I think the Kenyan judiciary has made, and the Kenyan legal community in general has made really significant strides here. It's very important to see actually how many women are both in the profession but also rising through the ranks even to the level of the Supreme Court. These things are important because, again, we're also part of the community. Similar questions around disability justice. At the moment, we really have a lot of efforts trying to think about how do we integrate disability justice, not just as a question of access to services, but even in the domain of civic space. What does it mean to think about disability and freedom of association or freedom of expression, right? And how do we, again, think creatively about evolving these ideas? And again, the law is one tool to do so. One thing I would say, too, is that, you know, as we think about this question of litigation and we think about jurisprudence, we often think, and I think as people who are technical in it, you think about the content of what you're doing and you think about the process and whether or not you win. But I would say another piece of work that we really need to focus on is the question of how you talk about it and communicate about it. Now, lawyers are by definition orators. But I think sometimes we only think about that storytelling in the context of the court, and we don't think about it in the context of the public. In particular, when you're looking at jurisprudence that sets precedent, how are you thinking about communicating this to community? Because people need to understand what is the thinking behind it. Justice has a texture. It has a texture, and it has deep thinking. Some months ago, we were in the Constitutional Court of South Africa, and Justice Albie Sachs was orating to us both the design of the building itself, but also the process of developing that South African constitution, which we know was groundbreaking for the world. And what was interesting was that, because of course they had come out of a tradition of apartheid, their existing jurisprudence couldn't give them very much, because it was a jurisprudence that was based on the idea that everybody is unequal, right? And so if they were trying to create a liberatory jurisprudence, they couldn't go there. So they said they scoured the case law across the world. They looked at dissenting opinion in the US Supreme Court, right? They looked at jurisprudence in other African jurisdictions that they could bring and put into creating a constitution that would be forward-looking, it would be inclusive, and would advance the vision of the independence that they had fought for. Okay? That's a story, and that's fascinating. And again, the depth of the thinking that is happening in the jurisprudence needs to be communicated out, because sometimes it's lost. It's not just the question of a judge said yes or no, right? That as both lawyers and judges, you're doing deep thinking about what it means to be an East African, okay? And I think it's very important that we think about whether or not you're really communicating that in other ways to the world, so that people are also appreciating your deep thinking and hearing it. And it's part, again, of a more collective conversation. Lastly, I would just say that, you know, the Ford Foundation, someone is needing directions. So this is actually the 60th anniversary of the Ford Foundation's presence in East Africa. Ford actually started funding in the African region in the 1950s, and it began by sending American academics here to study and think about where could Africa go. And then, of course, East Africa independence began 61, 62, 63. So the office was opened in 1963 in Nairobi. And the initial vision was to basically enable East Africans to run their own affairs. And so for many, many years, Ford invested in the major universities in the region and in programs that would, in essence, train people to be able to take control of their newly independent nations. And we had a very big program around training constitutional lawyers. So our history of the engagement in this question is quite long. I would say, as the granddaughter of one of the architects of Uganda's independence constitution, that I do think we need to think about why these things are important to us. Like I said, this is about us. This is about our societies, and it's about how we're thinking about living together. And we know that East Africa has always meant something to us. That, of course, we live in our nations, but that actually we've always had an East African way of thinking. The East African community was formed quite early, and people had helped each other, right, in the liberation process. And so we have to think about why, that we believe that there was something that and we know also the borders anyway were colonial, and that our communities transcend the borders. So it remains important to really think about us as East Africans, and not just as Kenyans, as Ugandans, as Tanzanians, etc., to think about in East Africa, and to dignify that through an engagement with the institutions that affirm that, including the East African Court. So again, good luck, enjoy. Innovate, imagine, think about, again, how you can use this to nourish the work that you do. And I agree about teaching onwards. Of course, we will make our efforts to sustain and enable that to happen. But it's also on all of us to continue the work. And so we look forward to seeing how you do that. Thank you.
State Registrar, East African Court of Justice, Country Director, Ford Foundation, Mr. Cohen,
Yes.
the representative of the President of the Law Society of Kenya, Mr. Francis Gimara, the Director, Programs, Center for Public Interest Litigation. We have our trainer here, Mr. Honoria, Dr. Honoria, the Chief Technical Officer. Other dignitaries present, participants, lawyers, the media fraternity. I've seen media here. Ladies and gentlemen, good morning once again.
Good morning.
My name, as introduced, is Yohane Masara, the current Principal Judge of the East African Court of Justice. I'm delighted to be here to participate in this session of the second phase of the trainings on good governance and rule of law in the EAC for national judiciaries and legal professionals. Allow me to thank you once again for inviting the EACJ to participate in this training and for asking me to come and give this brief opening remarks. First and foremost, I bring you greetings and well wishes from the Judge President, Mr. Nestor Kayobera, who would wish to have participated in person because the previous sessions he was opening them himself. But due to other exigencies of work, he could not participate in this training. Mr. Francis Gimara, we thank you. And we also thank Dr. Henry Honoria, who have been very instrumental in ensuring that these trainings are conducted as planned. And the sponsors of these trainings, Ford Foundation, we thank you very much for funding and facilitating these sessions. But most of all, I thank you, participants, lawyers, for taking time to come and participate in these vital sessions. Let me assure you that you will not regret the time you have taken to come and get these trainings. I've seen some of you who have appeared before us in the EACJ, and I think the discussion is going to be very live because they have hands-on in the activities of the court. They have appeared before us, and they know our expectations from advocates. As you may be aware, the court was inaugurated in November 2001. And so we have more than 20 years existence. And in that time, our jurisprudence has greatly expanded, and that is thanks to the diligence of individuals, NGOs, civil societies, cross-border commercial operators, and others. And the Kenya actors have been very instrumental in that endeavor. The EACJ has received a significant number of cases in the area of good governance and the rule of law, which is the main topic of these trainings. We have also dealt with cases arising from the protocols on the common market and the customs union, and few on the monetary union. And you may be also aware that recently the ESC concluded a protocol on the extension of the jurisdiction of the court, which will cover areas of trade and investment in the ESC region. So the jurisdiction of the court has expanded greatly in those 20 years. We started with only one case after 5 years of the court's existence, but now we are talking about 250 cases pending before the EACJ. So it's a big stride forward. We also deal with arbitration. So a few months ago, the APET division rendered its first 2 awards. So this is a positive sign in the increased mandate of the court. The court also has mandate to mediate. So when you file your case, you may also opt that let's settle this matter out of court or through the court's annex mediation. As I said, the representative of the president of the Kenya Law Society was talking about enforcement of our decisions. Luckily for the EACJ, most of our decisions have been implemented. We don't have complaints on those areas. I recently participated in the meeting of the ECOWAS court. Theirs is a big problem because the enforcement of the decisions of ECOWAS Court of Justice has been wanting. But ours, I don't know the reasons behind, but I would say more than 90% of our decisions have been implemented. And again, in the number of the trainees, you're lucky that you got 40. I think the Islam was less than 40, and it also included lawyers from the AG's office. And I think Kigali was also less than 40. So Nairobi, you're very lucky to get this number. So you should not count, you should not say it's a very low it's a good number. And as requested earlier on, you are going to be ambassadors. You're going to be trainers. You have been trained, so you'll be a trainer also of what you have learned. But also the commitment that has been given by Ford Foundation, and I think other sponsors will continue doing these trainings because we think it's very important that practitioners in the EACJ, they understand our jurisprudence. They also know the rules that we operate on. So I commend CEPE for conceptualizing this and organizing these trainings, and for these materials, for developing this. The litigator's manual is going to be very instrumental. I have gone through it, and it's very, very good. So take time to go through it, and also the source book. So let me now take this opportunity, without wasting much of your time, to declare that this training session is officially opened. Thank you, and wish you an informative engagement.
Thank you very much.
In terms of implementation of our decisions, we have not implemented. We have Article 38 of the treaty, which requires partner states to implement our decisions. And if they don't do that, then it's, they can be also sanctioned by their colleagues in terms of the treaty, because in the treaty, any breach, of course, including a breach of implementation of a decision, can attract sanctions. So we don't have a serious challenge with the implementation of our decisions. Yeah, that's what I can say up to now. Yeah.
I have 2 questions. One is, as journalists, we normally have a problem.
That sub-registry, it's working. Of course, the number of cases, you not equate the number of cases filed at the EACJ from Nairobi to the number of cases that are filed in the domestic courts. So the numbers will definitely be small. But we have a full-time person, a clerk, who is at the Milimani Court representing the EACJ. So in terms of dormancy of the registry, if it is that person not attending, we are not aware. But the last time I went, I visited, the registry was functioning, and they have all the details. If you go there, they can give you all the details of what it takes for you to file a case. Because the essence of opening sub-registries was to ease in the work you don't have to move to Arusha to file a case. You can just file it, and instantaneously, it is recorded in Arusha. So the essence of having those sub-registry is to facilitate the work of the court in our domestic, in our member countries. But in terms of the hierarchy of the courts, the Supreme Court of Kenya is supreme in terms of the judicial functions in Kenya. So matters filed in the domestic courts, the final arbiter or the final court is the Supreme Court of Kenya. The ESCJ cannot pretend to be supreme to all the Supreme Courts in terms of everything. For us, we are supreme in terms of interpretation of the treaty. So if a litigant comes to court and say a partner state, through one of its institutions, be it a court or be it whatever institution, it has violated the treaty, we have mandate to hear it. And that is essentially what happened in those cases. Because they are not coming to appeal the decision of the Supreme Court. They are coming to say that the Republic of Kenya, through one of its institutions, which is the Supreme Court of Kenya, violated the treaty in these terms. So for us, listening to those cases, we were discharging our mandate under Article 23 of the treaty, that we are the only court which is mandated to interpret the treaty for the establishment of the East African Community. So we are not challenging the decision of the Supreme Court of Kenya as an appellate court, because we don't have that appellate mandate. We can only hear matters in first instance where a party complains that a treaty has been violated. That's what I can say. Inatosha?